While thousands of IP infringement cases are handled under administrative procedures each year in Vietnam, only a few cases are heard by Vietnamese court. The administrative mechanism is said to be more expeditious, compact, simple, and economical than the lengthy trial, complicated, and costly procedures of civil mechanism. However, Vietnamese courts have heard a growing number of cases involving infringement of copyright, patent, trademark, and industry design. Please take a look at a typical patent infringement case that have been heard recently by the Vietnamese court. Through this case, we'd like to provide you with some critical takeaway if you wish to enforce against IPR infringement under civil procedures in Vietnam.
Case brief. Bayer, a French company, engages in manufacturing agrochemicals and chemicals used in agriculture. The plaintiff. The plaintiff was granted a patent in Vietnam. The subject matter protected under the patent is new agrochemical combinations of two known insecticides and other agrochemical products. The plaintiff discovered through market research that a Vietnamese company named Nong Phat manufactured pesticides named SESPA Gold and Hummer that contained the active ingredients, fipronil and imidacloprid, the combination protected by several claims of the plaintiff's patent. To substantiate the infringement allegation, the plaintiff sought an expert opinion witness from the Vietnam Intellectual Property Research Institute on the possibility of patent infringement, VIPRI. The VIPRI then rendered expert witness testimony in favor of the plaintiff. Based on the VIPRI's expert opinion, the plaintiff filed a lawsuit against Nong Phat before a court in Ho Chi Minh City, Vietnam for hearing. In the lawsuit petition, the plaintiff requested the court to order the defendant to cease manufacturing, distributing, storing, circulating, offering for sales, advertising the pesticides named SESPA Gold, to stop importing material, additives for manufacturing SESPA Gold and Hummer products, to recall the SESPA Gold products, to withdraw the dossier for registration for circulation of this product at Plant Protection Department, to not register for circulation of any products containing fipronil and imidacloprid, pay a compensation damage of 200 million Vietnamese dongs, approximately $8,700 for hiring lawyer to engage in the lawsuit and to make a public apology in local newspapers.
Counter actions from the defendant. The defendant, Nong Phat, did not accept the infringement accusation from the plaintiff, pleading that the ingredients, fipronil and imidacloprid, were imported from a foreign company who entrusted the defendant to use the above-mentioned ingredients and Plant Protection Department, upon receipt of the dossier for registration for circulation of SESPA Gold and Hummer products, reviewed, checked and determined that those products meet registration criteria. All of the foregoing evidence establishes that the defendant's products are lawful and that their manufacturing, distribution, storage, circulation, offering for sale, and advertising of the alleged pesticides complies with Vietnamese law. The defendant brought an invalidation action against the plaintiff's patent in the hope that the proceedings would be stayed by the court.
The IP Office of Vietnam, IP Vietnam, was requested to give its expert opinions, who then confirmed that although the cancellation action was filed, the plaintiff's patent was still in force. Court's judgment. Despite the pending invalidation of the plaintiff's patent, the court determined that the matter needed to be heard to protect the parties' legitimate rights and interests and to ensure compliance with applicable intellectual property laws. Taking the facts of the case into consideration, the court issued a judgment accepting the majority of the plaintiff's claims in the lawsuit petition. However, the defendant was ordered to pay the plaintiff 59,469,750 Vietnamese dongs, $2,600 in attorney's fees, for employing a lawyer to represent him in the action.
We are pleased to introduce Mr. Quân Nguyễn Vũ, partner and IP attorney, who is joining us today. Undoubtedly, invalidation actions is one of the most common defenses used by defendants in IPR infringement cases. And what is the purpose for this action? And if the IPR subject matter is being requested for invalidation in Vietnam, would the court suspend hearing the case, and what implications thereof?
In my opinion, an invalidation action firstly aims to challenge the patent validity, which serves as a legal basis for the plaintiff to take action. If the patent rights are invalidated, the patentee loses the right to pursue the infringement claims further. If this is the case, the patent holder will no longer have access to the commercial value and the right to utilize the invention exclusively. This is more serious to the patentee. However, in various cases, the objective of the patent invalidation is not always to invalidate the patent. By filing an invalidation action against the patent, the defendant in some situations simply wishes to put certain pressure on the plaintiff so that the plaintiff is forced to retreat or contemplate negotiating an out-of-court settlement with the defendant. When a dispute over patent rights arises in Vietnam, the Vietnamese enforcement agency frequently hold up on resolving the infringement matter until the IP Office of Vietnam issues a ruling on the invalidation proceeding. If the IPR subject matter is being requested for invalidation in Vietnam, the defendant action is supported by two provisions of the Civil Procedure Code and Decree 99, a sub-law instrument issued by the Vietnamese government in 2013. Given that this is a case involving IPR, the court compared the Civil Procedure Code and the law on intellectual property to determine which law should prevail in considering whether to suspend hearing the case or not. But the court and the procuracy eventually agree that the IP law should prevail because it is a specialized law. Given that no provisions are set out in Vietnam's IP law requiring the court to suspend the case, the court dismissed the defendant's motion and heard the case regardless of the pending patent invalidation and made a judgment in favor of the foreign patentee. In the above case, the court determined that despite the defendant's pending invalidation actions, the case must still be heard. The implications here are that firstly, it helps other enforcement authorities in Vietnam feel confident in handling IPR infringement cases in which a suspected infringer tried to create a dispute, making it as a pleading for further delay or cancellation or suspension of handling IPR infringement cases. Secondly, other Vietnamese courts could rely on the precedent established above when deciding similar cases. If courts insist on awaiting cancellation or invalidation rulings prior to issuing verdicts in IP dispute cases, plaintiffs could be subjected to an excessively protracted delay.
Besides cross action, what are other remedies available to IPR holders to fight against IPR infringement in Vietnam?
Subject to the nature and severity of IPR infringement, when an IPR infringement occurs, an IPR holder may resort to administrative, civil, or criminal route to fight thereagainst. In case the counterfeit or infringing products are imported into Vietnam, the IPR holders should consider taking border control measures to monitor inbound shipments and seize counterfeit at the border gates of Vietnam if detected. In Vietnam, patent rights can be enforced through administrative procedures before administrative enforcement authorities such as Market Management Agency, Police, Inspectorate of the Ministry of Science and Technology, Customs, and civil proceeding before a relevant court. Criminal route is not applicable to patent infringement in Vietnam. Civil action is currently not widely used in Vietnam because rights holders often feel that the courts are inexperienced. However, civil action is gaining in popularity because it provides unique remedies that are not available under administrative route, such as compensation for damages, public apology, and rectification and recovery of attorney fees.
So, So, what damages can IPR holder claim and what documents must be filed with the court to claim damages in Vietnam?
In the above lawsuit petition, the plaintiff requested the court in Vietnam to demand the defendant to pay, among other, an amount of 500 million Vietnam dong, approximately 22,000 US dollar. However, in the court hearing, the plaintiff decided to reduce the amount of damage compensation to just nearly 60 million Vietnam dong, which is lawyer fees paid by the plaintiff for hiring lawyers to engage in the lawsuit. Under Vietnam IP law, the plaintiff can recover reasonable legal fees as well as actual damages. Damages will be determined based on the actual losses suffered by the patent holder. The damage can include two types: material damages and spiritual damages. If the rate of compensation cannot be determined or quantified based on the usual grounds, such as monetary damages incurred by the plaintiff or the price of the assignment of IP rights, if the defendant is an assignee, the Vietnamese court is entitled to set an arbitrary compensation or statutory compensation of not more than 500 million Vietnam dong, approximately 22,000 US dollar. Attorney fee for the court action can, in principle, be recovered. To claim damages from infringers, the plaintiff must provide the court with evidence proving that they have been actually and directly damaged due to the IPR infringement caused by the infringers in Vietnam, such as loss in property or decrease in income, profits, or loss in business opportunity, or reasonable expenses for prevention and remedy of damage. The proof of damage based on which compensation is made must be clear and legitimate evidence showing the direct causal relation between the infringement and the damage. In light of the foregoing, court action is often recommended in case the infringement is severe, complicated, or on large scale. Even in case the IPR holders determine to bring a case to the court, they should firstly consider taking enforcement action against the infringers under administrative proceedings to secure as much infringement evidence as possible for civil actions to be subsequently taken.
In the above case, we find that plaintiff sought expert opinion from Vietnam Intellectual Property Research Institute, or we can say VIPRI. Could you please say something about VIPRI and why it is critical to obtain VIPRI's expert opinion before filing a petition for handling IPR infringement in Vietnam?
The VIPRI is an institute under the Ministry of Science and Technology, which is competent to deliver expert opinions on IP infringement cases concerning industrial property subject matters, such as inventions, industrial designs, trademarks, etc. The requester may request the VIPRI to determine scope of protection of industrial property rights, assess similarity, determine infringing element, and determine damages. However, at current state, due to limited human resources, the VIPRI only provides assessment services concerning inventions, industrial designs, geographical indication, and trademarks. The VIPRI will not opine on matters of unfair competition, trade name, or copyright. An IPR holder can file an infringement suit against a defendant without knowing for sure whether the defendant infringed on his right or not. All the plaintiff needs are a confirmation that his IP rights are being infringed. In Vietnam, IPR-related issues remain new and complicated to most enforcement officers who have limited knowledge and little experience in handling IPR-related cases. As such, before submitting a petition for handling IPR infringement in Vietnam, it is strongly recommended to file a request for expert witness or expertise opinion from the VIPRI. The VIPRI opinion takes the role of an evidence submitted by the plaintiff, and it will be reviewed by the court during the proceedings. A VIPRI opinion, if rendered in favor of rights holders, can be submitted to a Vietnamese enforcement agency in support of infringement claim. Then, based on the non-binding opinion from the VIPRI, the Vietnamese enforcement agency will consider whether to proceed with enforcing the IP rights of the petitioner or not. In detail, they will determine whether to proceed with an administrative raid or an issuance of sanctions such as fine, seizures, and destruction of infringing products. Court can also rule on IP cases, of course, and a VIPRI opinion can be persuasive evidence for the court to rule in favor of the rights holders.
According to our observations, the number of IPR cases heard by Vietnamese courts has increased in recent years. Vietnamese courts have satisfactorily resolved a large number of complex IP-related cases, and this is considered an encouraging signal, great efforts, and progress from the courts.
Civil lawsuits are becoming an inevitable change in the protection of IP rights in Vietnam. On the one hand, they maximize the benefit that only civil remedies can provide rights holders. On the other hand, they pave the way for improving the adjudication capacity of the Vietnamese court system, thereby increasing the effectiveness of IPR protection in Vietnam.